Appeal in the matter of Crane Bank Limited and others, and DFCU Bank Limited and others.
Good afternoon, my lords.
Good afternoon, Lord Panic. Before you set off, a couple of housekeeping things from the court. First of all, so far as this afternoon is concerned, we will need to rise at 4 because we have a swearing in of Mrs. Justice Stiers. And I have to get into my ceremonial robes. So we would also, I think, have a break for 5 minutes at 3 o'clock, so about halfway through. And you can bear that in mind for each session. We can have a break about halfway through the session. And the other thing I was just going to ask was how long you both think this appeal's going to take.
Well, I've told my friend I hope and expect to finish by lunchtime tomorrow. I may well do better than that. I'll do my best to do better than that. My friend, Mr. Chalfoon, I think require an hour and a day and an hour maximum for their submissions, and I would want no more than an hour for reply. So
we want to finish by lunchtime on Wednesday?
Yes, lunchtime or just after lunchtime on Wednesday. That's the plan.
Thank you.
As your lordships know, I appear for the appellants, Crane Bank and others. I appear with Hannah Brown, David Kaplan and Ben Louis. The first and second respondents are represented by my friends Joe Smooha, Sean Ochy and Jackie MacArthur. And the third to fifth respondents are represented by Mr. George Chalfoon. There are other respondents. They're not represented. They do not appear, but they have pleaded Foreign Act of State, FAS, and they're content to await the judgment of the court on that issue. The issue on the appeal, as your lordships will have seen, is a very precise issue. It's whether, as Judge Pelling held, the claimants are unable to pursue their claims of bribery by the respondents because of the Foreign Act of State doctrine, FAS. And it is our respectful submission that the judge erred in law in 4 respects. First of all, because this claim, or at least part of it, is not based on sovereign acts. It relates to commercial acts, and therefore the FAS doctrine does not apply. Our second submission is that in any event, the claim falls within the so-called Kirkpatrick exception to the FAS doctrine. That is where the case can be determined without the court needing to find that the conduct of the Ugandan state or its officials was invalid. The third submission is a very important matter for the development of the law. We say in any event, in relation to this claim based on bribery and corruption, the public policy exception to the FAS doctrine applies, or at least it's arguable that it applies, so that the matter should go to trial and the facts be found. And there's a fourth submission, a short submission. We say in any event, the application of the FAS doctrine to this claim would breach the appellant's rights under Article 6 of the European Convention on Human Rights. Lords, I think that's the logical order in which to take the points, and subject to a contrary direction from the court, that's how I propose to proceed. I don't at this stage, or indeed at all, want to say very much about the substantive case for the appellants. The court's not determining anything relating to that. It's set out in our re-amended particulars of claim. In summary, we say, and your lordships have seen this, we say that officials at the Bank of Uganda and others were involved in a corrupt scheme to seize control of the first appellant, CBL, one of Uganda's leading banks, and sell it, or in the event sell its assets. And pursuant to that scheme, CBL was taken into statutory management by BOU on the 20th of October 2016. On the 24th of January 2017, CBL was placed into receivership so that the BOU, as the receiver, could sell off the assets and liabilities of CBL to the first respondent, to the DFCU Bank, in what we say was a corrupt agreement. The officials agreed to this, we say, because they were bribed by the respondents. The agreement, the purchase of assets and assumption of liabilities agreement, the P&A agreement between the first respondent and the BOU acting as receiver for the sale and purchase of our assets and liabilities occurred on the 25th of January 2017. That was the day after CBL was put into receivership.
No.
There's no dispute in your Lordship's court that the appellant claimants have at least a properly arguable case on the merits under Ugandan law, that the defendants conspired with the BOU and its officers to use unlawful means, in particular bribery of BOU officials. There's also a claim against the first respondent bank as constructive trustee, and there's a claim for profits made as a result of the corrupt transaction.
Can I ask this? You're now putting bribery front and centre of the claim, as I understand it. And I entirely understand that. You say a private act of bribery of a receiver, your agent, to sell at an undervalue. Seems extremely straightforward private act. But I can't see in the pleadings at the moment that you have made a claim in bribery against the defendants. In fact, I can't see that you've even pleaded the tort of bribery. Have I misunderstood that?
Well, the wrongdoing is set out in paragraph 69 of the amended particulars, which your Lordships will find in the core bundle at tab 7, starting at page 125. And your Lordships will see at 69, pending disclosure, the claimants have identified the following as the unlawful means by which the conspiracy was effected after the defendants joined the corrupt scheme. Because, of course, we're only alleging wrongdoing after we joined the alleged corrupt scheme. And A deals with the wrongdoing of BOU. And they became parties to a new conspiracy, and the conspiracy included on page 126 at 3 the crime of bribery under section 5B of the Anti-Corruption Act by the solicitation and acceptance on the part of the officers and or agents of the BOU of the gratification identified. And then there's abuse of office, then there's the crime of causing financial loss. And then under M on page 128, the offer by the first respondent, DFCU Bank, to enter into, and the entry by the bank into, an agreement transaction with the BOU with the features and purposes identified in what I've already read out, which conduct amounted to the crime of corruption under the Anti-Corruption Act by offering and granting, directly or indirectly, to the officers of BOU and or agents benefits in the form of concealment of their prior wrongdoing, etc., etc. Crime of corruption under 2. 3, the crime of bribery by conferring on the officers and agents benefits in the form of concealment of their prior wrongdoing and the takeover, secret transfer of a portfolio, etc., etc. So I would respectfully submit that is sufficient to constitute an assertion, a plea, that there was bribery by the first respondent and other respondents, which had effect on the mind of the BOU.
My question is a bit more simple, I think. Why aren't you claiming, why aren't you pleading the tort of bribery against the defendants?
It's a very good question. I don't know the answer to that, to be quite frank. In my submission, what we have pleaded amounts to that, perhaps in a more complicated way.
If you look at the claim form, it doesn't even mention bribery, does it?
I think what you've nailed your colours to, so far as that plea is concerned, is an unlawful means conspiracy.
Yes.
Where, so far as this bit of it's concerned, the unlawful means is the crime or the crimes of corrupt bribery and the crimes of corruption.
Yes.
Where the co-conspirators are at least the Bank of Uganda and its officials on the one hand, and the main defendant here and its officials on the other hand. And that case doesn't depend upon the previous corrupt scheme, as it were. That's all part of the background.
Yes.
And that's really the point you're seeking to make.
Well, it is, my lord. I mean, I'm conscious that we can only claim for damages in respect of what happened after we came on the scene. And the pleading sets out the context in which we came on the scene, that there was already a scheme to take control of
When
the
you say
first.
we, you mean
The first appellant, yes. But by the time that Crane Bank came on the scheme, there was already.
No, I think you're getting confused.
I'm sorry, CBL. I'm sorry. By the time CBL came on the scene, there was already by the time the DFCU Bank came on the scene. I'm sorry. By the time the DFCU Bank came on the scene, there was already a corrupt scheme that had been devised by the BOU to take control of the appellant bank and sell its assets for corrupt purposes.
Yeah.
But I do take your lordship's point. It may be that we could and should have pleaded it in a simpler way. But can I consider that and make further submissions on it at an appropriate moment?
yes.
Yeah.
But just to be clear, it seems to be your very simple case is our agent was bribed to sell our assets at an undervalue.
Yes, yes. Which we say in relation to the first question, commercial or sovereign. This is a private commercial act. That's the simplest way of disposing of this appeal. And I have no interest in complicating matters, far from it. This appeal has been presented on the basis, so far, on the basis that there is no dispute that we have at least a properly arguable claim in relation to what is set out in the pleadings. But as I say, I do take your lordship's point. There's a simpler way of looking at it.
But the answer, maybe jumping far ahead, but as I understand the answer, which comes from the respondents to the very simple case, is, you can't say that because you have pleaded a much bigger corrupt scheme.
Yes.
I'm not sure the way to hear that developed, but you say you can pursue that much narrower, simpler claim anyway.
Well, it is my submission that if the court takes the view that part of our pleading involves sovereign acts, the court will allow such part of the pleading as concerns commercial acts to go forward. And the recent Ukraine case in the Supreme Court, which concerned, or which was decided by reference to the Kirkpatrick exception, makes expressly plain that although the pleading was too wide, the court would not dispose of the case on that basis, but would allow the claimants to amend in order to bring the case within what is properly the scope of the Kirkpatrick defence. And I would say the same must apply in relation to commercial and sovereign acts. But let me reflect, if I may, on what your lordship puts to me. The foreign act of state principle, your lordships are very, very familiar with this, but can I just remind your lordships, authorities, volume 7, tab 34, where your lordships will find, sub 7 of the authorities, volume 7 authorities, tab 34, the Venezuela case, the Maduro case, and Lord Lloyd Jones, speaking for the Supreme Court, summarised the principle on the final page, at page 254. Are your lordships using the paper bundles? I think your lordships are.
Yeah.
It's page 254 of the law report, tab 34.
Yeah.
Paragraph 181. 2A, there exists a rule of domestic law that, subject to important exceptions, courts in this jurisdiction will not adjudicate or sit in judgment on the lawfulness or validity under its own laws of an executive act of a foreign state performed within the territory of that state. And at paragraph 113, if one turns back in the judgment, law report reference page 229, paragraph 113 refers to Lord Newburger's majority judgment for the Supreme Court in Belhaj, and this is Rule 2 on the top of page 230. The second rule is the courts of this country will recognise, will not question the effect of an act of a foreign state's executive in relation to any acts which take place or take effect within the territory of that state. The judge below, not particularly helpfully, referred to this as Rule 1. It's Rule 2 of Lord Newburger's rules. That's paragraph 15 of the judgment below. And at paragraph 135 of Lord Lloyd Jones's judgment for the Supreme Court, his lordship explains the basis of this rule, picking it up near the bottom of page 237 of the law report, the last 4 lines. That's the rule, is founded, this is page 237, last 4 lines, it's founded on the respect due to the sovereignty and independence of foreign states. It's intended to promote comity in interstate relations. While the same rationale underpins state immunity, the rule is distinct from state immunity. It's not required by international law. It's not founded on personal immunity. The rule does not turn on a conventional application of choice of law rules, nor does it depend on the lawfulness of the conduct under the law of the state in question. On the contrary, it's an exclusionary rule limiting the power of courts to decide certain issues as to the legality or validity of the conduct of foreign states within their proper jurisdiction. It operates not by reference to law, but by reference to the sovereign character of the conduct which forms the subject matter of the proceedings. At paragraph 136, Lord Lloyd Jones recognised a number of limitations and exceptions, in particular at subparagraph 4, just under F. The doctrine does not apply where the conduct of the foreign state is of a commercial as opposed to a sovereign character, and authority is cited. And in the present case, the judge below held, it was paragraphs 29 to 30 of his judgment, that the claim is concerned with sovereign acts, it's not concerned with commercial acts, and so it is within the scope of the FAS doctrine. Our submission is that the agreement between the first defendant and the BOU acting as receiver was a commercial act, even though we recognise that what preceded it included sovereign acts. The receiver was acting for and on behalf of CBL. This was a private law agreement. This principle that the FAS doctrine only applies to a sovereign act and not to a commercial transaction can also be found in Belhaj, and there's a useful statement of principle by Lord Sumption. If your lordships have volume 4 of the authorities at tab number 22, the relevant paragraph is on page 1132 of the law report, and it's paragraph 199, Lords. Bottom of page 1132, 5 lines up from the end. This is paragraph 199. Lord Sumption says the second, commonly called Foreign Act of State, is that the courts will not adjudicate upon the lawfulness or validity of certain sovereign acts of foreign states. For this purpose, a sovereign act means the same as it does in the law of state immunity. It is an act done jure imperii, as opposed to a commercial transaction or other act of a private law character. That's the principle. And because Lord Sumption refers there to the law of state immunity, it is helpful in my submission to go to the leading authority on the distinction between sovereign acts and commercial acts, which is the E Congresso del Partido case, the speech of Lord Wilberforce for the Appellate Committee, Playa Larga, which is in Authorities Volume 1 at tab number 6. And can I pick it up again? It'd be very familiar to the court, but can I pick it up, please, at page 261 in the speech of Lord Wilberforce for the House. And Lord Wilberforce, yes, if one picks it up at the top of page 262, one sees this. Its value, that's Lord Denning's judgment, in the present case lies in the reasoning that if the act in question is of a commercial nature, the fact that it was done for governmental or political reasons does not attract sovereign immunity. So it's not the purpose, it's not the motive, it's not the background, it's the nature of the act itself that is determinative. At letter F on the same page, page 262, it's necessary to consider what is the relevant act which forms the basis of the claim. Is this an act jure gestionis, or is it an act jure imperii? Is it, to adopt the translations of these catchwords, a private act, or is it a sovereign or public act? A private act meaning in this context an act of a private law character, such as a private citizen might have entered into. And then can I also remind the court of 267 under letter B, 267 letter B, where Lord Wilberforce sums up what he said. The conclusion which emerges is that in considering under the restrictive theory whether state immunity should be granted or not, the court must consider the whole context in which the claim against the state is made, with a view to deciding whether the relevant act upon which the claim is based should, in that context, be considered as fairly within an area of activity, trading or commercial, or otherwise of a private law character in which the state has chosen to engage, or whether the relevant act should be considered as having been done outside that area and within the sphere of governmental or sovereign activity. And 269 letter C, Lord Wilberforce approves although he disagrees with Mr. Justice Goff as he then was on the application, Lord Wilberforce agrees with the test stated by Mr. Justice Goff. It is not just that the purpose or motive of the Act is to serve the purposes of the state, but the Act is of its own character a governmental act, as opposed to an act which any private citizen can perform. So that's the test. And there's much authority applying that test, that one needs to identify whether the specific act, which is the subject of the proceedings, is sovereign in nature or commercial in nature. There are statements, for example, from Lord Denning, that although the maintenance of an army is plainly a sovereign act, the acquisition of boots and bullets will not be. That's trend text. I don't invite the court to turn it up, but that's what Lord Denning says in trend text. Authorities, Volume 1, Tab 5, at 558E. And it's also, in my submission, very important to note that a course of conduct may begin by constituting a sovereign act, but subsequently involve private acts. And a very good example of that is the Kuwait Airways case, which your lordships will find at Volume 1, Tab 9. I note from page 1150 that one of the counsel was a much younger Mr. Smuhar. And this case concerned the acquisition, to use a neutral term, by Iraq of the airlines of Kuwait at the start of the First Gulf War. And what their lordships held by a majority was that although the initial transportation of Kuwait Airways aircraft by Iraq to Iraq was a sovereign act, the subsequent use of the aircraft by Iraq was not. It was a commercial act. And one sees the context from Lord Goff's speech for the majority at 1151, page 1151, where he sets out what had happened. The present proceedings, this is just under letter A, the present proceedings are concerned with 10 civil aircraft, the property of Kuwait Airways, the plaintiffs in the action, and the appellants. These aircraft were at Kuwait Airport at the time of the invasion, and they were seized, they were removed to Iraq. It's enough for present purposes to record that on the 6th of August 1990, the Iraqi Minister of Transport and Communications, the minister responsible for civil aviation, directed the Director General of Iraq Airways, IAC, the First Defendants and the First Respondents, to arrange for these aircraft to be brought to Iraq. And then at D, on the 17th of September, there came into effect a resolution, Resolution 369, which purported to dissolve KAC and to transfer all its assets to IAC, the Iraqi company. Until then, although IAC had carried out basic maintenance, it made no use of the KAC aircraft, Kuwait aircraft. Thereafter, however, the Iraqi corporation treated the aircraft as its own, incorporating them into its fleet and making such use of them as it could in the prevailing circumstances. And if your lordship please would then turn to 1156 at the bottom of the page, letter H, 1156, Lord Goff continues, it's unnecessary for the purposes of the present case to trace the adoption by English law of the distinction between acta jure imperii, which when performed by a foreign sovereign attract immunity, and acta jure gestionis which do not. And then he traces the development through to E Congresso del Partido, which I've shown the court. In the latter case, the members of the committee were in agreement with that the applicable principles were as stated by Lord Wilberforce, although there was disagreement as to the application to one or two cases on appeal before them. Your lordships can therefore turn to Lord Wilberforce's speech as providing an authoritative statement of the principles underlying the distinction. And that's what Lord Gough then does. And at 1163, he applies this principle. At the top of page 1163, Lord Gough says, I approach the matter as follows. First, the taking of the aircraft and their removal from Kuwait airport to Iraq constituted an exercise of governmental power by the state of Iraq. He refers to Mr. Chambers' submission, says it was forced in the argument, but I am satisfied that in so acting, IAC was not just doing a job of work, but was closely involved with the state of Iraq in the last stage of an enterprise which entailed both the seizure of the aircraft and their removal to Iraq to be used for such purposes as the government of Iraq should direct, which in point of fact was to be their incorporation into IAC's fleet. On this basis, I am of the opinion that IAC in so acting was acting in the exercise of sovereign authority. But as I see the position, said Lord Gough, the situation changed after the resolution came into effect. Thereafter, as I see it, it cannot be said that IAC's retention and use of the aircraft as its own constituted acts done in the exercise of sovereign authority. They were acts done by it in consequence of the vesting or purported vesting of the aircraft in it by legislative decree, and I emphasise those words. Certainly, contrary to the argument of Mr. Beloff, the fact that the resolution was itself a governmental act by the state of Iraq could not of itself render IAC's consequent retention and use of the aircrafts a governmental act. And then if I leave a bit out and pick it up again just above F, does it make any difference that in the present case the state entity was at an earlier stage involved in the seizure of the property from the former owner in the exercise of sovereign authority? And Lord Gough answers, I for my part cannot see that the characterisation as an act jure imperii of the earlier involvement by the entity in the act of seizure can, on the facts of the present case, be determinative of the characterisation of the subsequent retention and use of the property by the state entity following the formal vesting of the property in the entity by a legislative act of the state. And I say that's important because it demonstrates not merely that you have to look at the specific act of which complaint is made, and it's not enough that there were earlier sovereign acts which had a causal link. Plainly there's a causal link here, but it's also not the case that it is a sovereign act because the authority of the defendant to use the property is the consequence of a formal sovereign act of the state. There, the resolution, here, the statutory authority and the exercise of it conferring power on the BOU to act as receiver. So we rely on that authority. We say in the present case the court is concerned with a private act, a private law agreement to sell assets and liabilities of a company. It's an act which by its nature could be carried out by a private party. It doesn't assist, my friends, in my submission that the motive or purpose of the sale was to implement a sovereign decision, see Lord Wilberforce, it doesn't answer the case that the sale was the consequence of an earlier sovereign decision to take the bank under statutory management and then into receivership. See Kuwaiti Airways. The sale was by BOU as receiver, and therefore it was a sale for and on behalf of CBL. If any claim arose against DFCU Bank under the P&A agreement, the claim would be brought by CBU against DFCU and would not be brought by BOU unless BOU was still acting as receiver for and on behalf of CBL. And your lordships may have noted from the pleadings that our case is that the Ugandan courts have held that the receivership ended on the 20th of January 2018, and that on that date the management of CBL reverted to the shareholders after that date. That's amended particulars of claim. I don't ask the court to turn it up, but it's the amended particulars of claim at paragraphs 8G, 8HA and 8HD, which can be found in Core Bundle 7, pages 96 to 98. My lords, we've referred to a number of other cases which we say are analogous to the present. Can I deal with them speedily, I hope? The first of them is Banco Nacional de Cuba, which is Authorities Volume 2 at tab number 10. This is a case, Volume 2, tab number 10, a decision of Mr. Justice Lightman. And here it was being alleged that a sale of a UK subsidiary of the Cuban Central Bank to another Cuban state entity as part of a reorganization of the Cuban central banking system gave rise to a liability under the Insolvency Act. And the acquisition of the UK subsidiary was part and parcel of the wider reorganization in Cuba, as appears, and I'm not going to read it all out, but it appears from paragraphs 3, 7 and 9 of the judgment of Mr. Justice Lightman. And the complaint, see paragraph 5, was that the price paid did not reflect, was not designed to reflect the subsidiary's true value. And it was argued that the claim was barred by sovereign immunity because the relevant acts were sovereign in nature. And Mr. Justice Lightman rejected that contention. He rejected it at paragraph 28, which is on page 2053 of the judgment. He says BNC and BCC entered into what was in form a private law contract and completed it as such. There's no evidence the sale was pursuant to any legislative or executive direction. In this respect, the agreement is in quite different position from the rest of the reorganisation, which was effected by legislation. In the language of Lord Wilberforce, everything was done as between vendor and purchaser. There was no exercise, no need for exercise of sovereign powers. The private law character of the transaction is not discovered by the context in which the agreement was executed, i.e. the fact that the parties to it regarded the transfer of the shares as an obvious and necessary sequel to the statutory organisation, nor is its private law character controverted by the purpose or motive behind the transaction of serving the interests of the state in bringing to fruition the completion of the reorganisation of banking in the final form which it sought. I therefore hold that the entry into and completion of the agreement were commercial rather than governmental, albeit the parties to the agreement were both state-owned entities, and that accordingly there was no immunity in respect of the transaction. It is true, and indeed the first and second respondents make this point, it's paragraph 22 of their skeleton argument, that here, as Mr. Justice Lightman noted in that paragraph, we were dealing with the sale by a central bank of its own subsidiary to a state entity. We respond that that doesn't assist on this issue of the nature of the act, commercial or sovereign. The sale in that case was part, as Mr. Justice Lightman said, of the statutory reorganisation, but nevertheless, the act itself was a private law agreement, was commercial in nature. We also draw attention to the AMPAC Group case, an American authority, American Federal Court, at volume 8 of the authorities, tab 42. This is the United States District Court. What had happened here, this is volume 8, tab 42, AMPAC were complaining that they'd won a bid to acquire a Honduran company that was put up for auction by a state-owned entity responsible for privatizations. But although they'd won the bid, the company was not transferred to it. Instead, the Honduran government didn't approve the sale and it nullified the bid process. And AMPAC brought a claim in the federal court in Florida alleging fraud, misrepresentation, breach of contract, and the defendants sought to have the claim dismissed on grounds which included state immunity and the FAS doctrine. And the judge, District Judge King, dismissed the action at 976 in the left-hand column, in the final completed paragraph in the left-hand column. Here, defendants argue that privatising a national cement industry is an action that could only be taken by a foreign sovereign and is thus not commercial activity. Privatisation, defendants argue, is merely the flip side of nationalisation, a quintessentially sovereign prerogative. If nationalisation is an activity that cannot be challenged in the courts, so too is privatisation. And then at the bottom of the page, left-hand column, the last line, the purpose of the transaction, devolution of a state-owned business as part of a planned return to a market economy, is irrelevant to the inquiry. The sale of a company from its owners to the highest bidder is a routine commercial transaction. And there's then a reference to a Supreme Court decision in Weltover, where foreign bondholders brought an action in the federal court of New York against Argentina, arising out of Argentina's unilaterally rescheduling of the maturity dates for payment on its bonds. Argentina lacked sufficient foreign exchange to retire certain bonds, and they issued a presidential decree extending the time for payment. The government action was part of an emergency currency stabilization plan. A unanimous Supreme Court held that Argentina's emergency measure to stabilize its own currency enjoyed no immunity in United States law under the FSIA. In determining whether governmental conduct constitutes commercial activity, the decision reaffirmed and clarified the distinction between the nature and purpose of the activity. The question is not whether the foreign government is acting with a profit motive or instead with the aim of fulfilling uniquely sovereign objectives. Rather, the issue is whether the particular actions the foreign state performs, whatever the motive behind them, are the types of actions by which a private party engages in trade and traffic or commerce, very similar to Wilberforce's test. And the Supreme Court concluded it's irrelevant why Argentina participated in the bond market in the manner of a private actor. It matters only that it did so. And the judge applied that reasoning at 978. In the middle of the left-hand column, as discussed above, the underlying government action here is unquestionably commercial in nature. And therefore the Act of State doctrine presents no obstacle to jurisdiction in the interest in the present case. One other case, WMW Machinery, which is the next tab, tab 43, another federal court decision in New York. Here, a German government agency, the Treuhand, had been created to oversee the privatization of East German entities, and the plaintiffs had contracted with one such entity, and their claim was that the Treuhand had interfered with that contract. The government agency had interfered, and the defendants moved for summary judgment, including on FAS grounds, and District Judge Parker rejected that claim at 740. In the left-hand column, Lord, the large paragraph in the middle of the left-hand column, at the beginning of that, he said the Treuhand's role as the entity responsible for privatising state-owned businesses more aptly describes Treuhand's purpose, that is the reason why the foreign state engaged in the activity. And in the right-hand column, at the same level down, the actions that form the basis of plaintiff's claims reflect an exercise of powers that can also be exercised by private citizens. They're akin to those the controlling stockholder of a corporation might take as a player in the private market. So we rely on all of that. And yes, so that's the authorities. The first and second respondents, it's paragraph 22 of their skeleton argument, they seek to distinguish these US cases on the basis that they concern a materially different US foreign act of state principle. But as I hope the court has seen from the citations I've given, the federal courts were applying the same principles as Lord Wilberforce, the same principles in distinguishing between sovereign acts and commercial acts. And these cases, and indeed the authority of Mr. Justice Lightman, they are all in the same direction. They all demonstrate that the fact that the government entity is acting for a government purpose does not mean that the act of which complaint is made is a sovereign act. The question is whether the nature of the act is one that could be carried out by private parties. And we say it is elementary that a private party can enter into a private law sale agreement. And we repeat that all that was happening here was that the BOU was standing in the shoes of the CBL, which could itself have sold its assets and liabilities. How did the judge below deal with this issue? If we go to the core bundle, please, at tab number 5, the judge dealt with this starting at page 65. And at first we point out that the judge's starting point was to address what he understood to be a claim about the expropriation of property by the state. We see that at paragraph 28, where a claim is started concerning property seized by the government of the foreign territory in which it is situated, and that is what in substance is alleged in this case. The court will not examine whether the foreign government concerned acted validly or not within that government's own domestic laws. Now, my lords, of course we accept that an expropriation by the state is a sovereign act, but the relevant act with which the claim is concerned is not the act of the taking of the property by the state. Our complaint, our claim, concerns the private law sale entered into by the BOU, acting as receiver of CBL. The second error, in my respectful submission by the judge, can also be seen in paragraph 28, because the judge adopts the approach that acts are necessarily sovereign in nature if they're carried out by the BOU, exercising statutory powers for regulatory purposes. And in paragraph 28 of the judgment, 5 lines from the end of paragraph 28, the judge says the acts of a state's central bank, when exercising regulatory and supervisory powers conferred on it by the domestic laws of that state, for the purpose of enabling it to manage, regulate and supervise the banking and financial system of that state, are such acts, that's inherently governmental, at least when carried out within the territorial borders of that state. My respectful submission, no. One must look at the nature of the act in question, not at the statutory origin of the powers which are being exercised. And the judge repeated that view at paragraph 29. I now turn to the acts relevant in these proceedings. In this case, all the relevant acts took place in Uganda. None of the acts could have been carried out by a private citizen in Uganda. Each of the acts relied on was an act which could only be carried out by the BOU pursuant to the statutory supervisory and regulatory powers referred to earlier. Whether such acts were unlawful is neither here nor there. The acts of which complaint were made were executive acts that were and could only have been carried out by the BOU using its statutory powers. Well, again, I say that's, with great respect, the wrong test. It's not the test that Lord Wilberforce stated for the reasons that I have given. If it matters, there was evidence before the judge that in acting as a receiver, and indeed as statutory manager before that, the BOU owed private law duties to CBL, including duties that any receiver would have owed under Ugandan law. And
I think that was positively pleaded, wasn't it, paragraph 40?
yes, indeed, precisely so.
Therefore, it's to be assumed for the purposes of the
Indeed.
jurisdiction.
Oh, well, I'm grateful. Your Lordship's absolutely right. And there was evidence, and because there was evidence, the respondents did not dispute that for present purposes. They're perfectly entitled to argue to the contrary at trial, but there's no dispute at this stage of the argument. The third error made by the judge was to, in my submission, was to treat the entirety of the actions taken by the BOU from mid-2016 to 2017 as a single act for the purposes of assessing whether these acts were commercial or sovereign. And we see that at paragraph 30 of the judgment, picking it up 6 lines down. The sale came only after the takeover of CBL during 2016 and early 2017 by the BOU, pursuant to its statutory powers under the FIA. There's no answer to say that private individuals can enter into corrupt arrangements. What is critical is the nature of the corrupt scheme alleged. In this case, it's alleged the BOU as an executive organ of the state used its statutory and regulatory powers unlawfully to facilitate the sales at an undervalue. That is something that a private individual could not do. It's only something the BOU as part of the executive could do by reason of the powers conferred on it by the constitution and legislation referred to earlier. Well, that's like saying in the Kuwait case that they could only use the aircraft because of the sovereign acts that had previously taken place. What matters is the nature of the specific act of which complaint is made, and the specific act is the sale as receiver of the assets and liabilities of CBL. It's also of interest to note that the judge himself says at the beginning of paragraph 30 of his judgment this. He says, "I'm willing to accept that the act of selling assets was an act that at least realistically, arguably, was private or commercial, but that does not assist." Why did the judge say it doesn't assist? Because in the judge's view, that might be relevant to a claim as between the buyer and the BOU as vendor, but that is not this case. That's the beginning of paragraph 30. Well, as we say, the judge was plainly correct to recognise that a sale by the BOU to a purchaser could well be, we put it higher, could well be a commercial act. We say it plainly was. And that's even though the BOU was only in a position to make the sale because of the statutory context, what had gone before. We say a private or commercial act does not cease to be in that category and does not become sovereign in nature because of the identity of the claimant in the particular case. If the person to whom BOU sold the assets could bring a claim based on the sale being a commercial act, then the appellants can bring a claim based on the same sale without being said that it was not a commercial act.
Well, to be fair to the judge, you are now focusing your guns entirely on the sale by receivers, but that's really not the way the claim is presented in the pleading, where you define in paragraph 8C the corrupt scheme, which is said to be takeover and resolution by the BOU purportedly pursuant to its statutory powers. And then it sets out the act to rely upon and doesn't get to the receivership until paragraph 39. So I understand entirely what you're now saying. I think it's a little unfair to the judge.
Well, I don't want to be unfair.
That he's got it all wrong because, in a way, he's just looking at what you said and explained in some detail was the corrupt scheme.
Yes, and that's why he says in 30 what is critical is the nature of the corrupt scheme alleged.
Yeah. Well, the pleadings were amended, and the pleadings were amended in particular to include paragraph 69A, which is on page 130, and that was as a result of the hearing before Mr. Richard Salter, who was sitting as a deputy judge, who criticised or asked penetrating questions of the appellants relating to the nature of their claim. And paragraph 69A did say, for the avoidance of doubt, whilst the unlawful means identified began before the defendants joined the corrupt scheme, alternatively formed a new conspiracy with BOU and its officers and agents, they continued or recurred thereafter, and the claimants rely on them only insofar as they did so. We say that we did make our position very clear before the judge, but it doesn't much matter. I'm hope entitled to put the case as I now do, and it's no part it's no necessary part of my case to establish that the judge is somehow at fault. What matters in my submission is what the correct answer is, and the reasoning given by the judge in my submission provides no answer to the way in which I'm putting the case before this court. That's how I put it.
While we're looking at the way that you're now putting the case, can I just understand one thing? You started by saying the judge had gone wrong in 4 respects. And I understood that those to equate, perhaps not in the same order, but to grounds 2 to 5 of your notice of appeal. The first ground, am I right, you're not pursuing that anymore?
Can your lordship remind me? I'm sorry, I can't remember what the first ground was.
The first ground is that he shouldn't have determined these matters, but should have.
Oh, no. I say that point is applicable in relation to public policy, which is very much a developing area of the law. But I do accept, I hope fairly accept, that in relation to the commercial sovereign distinction, this court will make a judgment. And
It might be said it's difficult to argue this is a developing area of the law before this court.
yes,
In the light of my judgment in Coes Ralton.
well, I'm going to deal with that when I come to public policy, my lord. Yes.
Is that a convenient moment just to have a break? for 5 minutes?
It is, my lord, yes. Thank you very much.
All right.
Hello.
This same one.
You want me to? Okay. 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 It does. You need to show me the particular paragraph. I'm not going to read it all out to you. What's this supplementary bundle or what?
Tab 19.
That's what?
45, 46.
That's really wrong, isn't it?
And then you've got a 51, you've missed a wide notes of your statutory management. That's fine. So the exactly.
Yeah. Yeah, okay.
All eyes.
My Lords, we've just been looking at our skeleton argument below. To the extent that it matters, we have that at Supplementary Bundle Volume 2, and it's tab 19. And can I invite the Court's attention to the paragraphs in which we put the case as I'm putting it today, and the relevant paragraphs are on page 439 of the electronic bundle, page 14 of the text, paragraphs 45, 46, 47, and over the page, paragraph 49. That is the case that I'm now putting. I also mentioned earlier this afternoon that in the Ukraine case, dealing with the Kirkpatrick exception to which I'm coming, the Supreme Court adopted the approach in relation to the FAS doctrine that if the pleadings were defective but the claim was maintainable, then the claimant should be given permission to amend. And one sees this, the Ukraine case is in volume 7 of the authorities, tab number 35. The transcribers have asked me to give the electronic references, and I'm very happy to do so. It starts at 1998. And the Kirkpatrick exception is addressed by the Supreme Court from paragraph 184 onwards, and at paragraph 191 the court finds that the Kirkpatrick exception did apply, and therefore it's not necessary to deal with whether it was a commercial act, and they didn't need to deal with public policy. And at 197, paragraph 197, which is on electronic page 2069, the Supreme Court says Ukraine will have to amend its pleadings so as to focus more clearly than at present its case of duress of the person and goods based on the Russian Federation's alleged threats of the use of force. Its averments in respect of the trade restriction are also material, as we've explained. On the other hand, its averments in respect of alleged breaches of international law, etc., introduce issues which are not material to the defence of duress and which is unnecessary and inappropriate for the court to make any determination. Those averments ought not, therefore, to go forward for trial, and that's because the Kirkpatrick exception did not apply to those. So that's the approach that the Supreme Court adopted. If necessary, we would seek permission to amend in accordance with the judgment of the courts. My Lord, subject to other questions, that's the first ground. That's the first issue.
Lord Carnworth dissented on duress, is that right?
I'm sorry, my Lord.
Lord Carnworth dissented on duress.
Yes, he did. He did. Not on any issue of principle relating to the scope of the Kirkpatrick exception. As I say, their lordships did not deal with commercial sovereign, did
No.
not deal with public policy because they said the Kirkpatrick exception applied. So that's what I want to say, my lords, on commercial or sovereign. The second point on the appeal is the Kirkpatrick exception. And if we go back, please, to the Maduro case, the Venezuela case, at Authorities Volume 7, at tab 34, electronic 1899, Lord Lloyd Jones for the court addressed this exception at page 238 of the law report, page 1981. It's paragraph 136 at subparagraph 5, where his lordship says the doctrine, that's FAS, does not apply where the only issue is whether certain acts have occurred, as opposed to where the court is asked to inquire into them for the purpose of adjudicating on their legal effectiveness. See Kirkpatrick, in particular, United States Supreme Courts, and UCOS. And at paragraph 151 of the same judgment, paragraph 151 is on page 244 of the law report. Letter B, his lordship referred to the observations of Lord Justice Ricks in UCOS Capital. His lordship said, now in our judgment, we would agree that challenges to foreign acts of state in order to invoke the Act of State doctrine must, as Lord Wilberforce put it, lie at the heart of a case and not be a matter of merely ancillary or collateral aspersion, and that a test of necessity is to a decision may therefore be a useful test. And his lordship, Lord Lloyd Jones, also referred to what Lord Neuberger had said in Bell Hadj. The common law regards it as inappropriate for an English court to decide whether a foreign state's executive action infringed the law of the state, at least where that is not the purpose of the proceedings. And there's a reference to Lord Sumption's observations in Bell Hadj on Kirkpatrick. The Act of State doctrine applies only where the invalidity or unlawfulness of the state's sovereign acts is part of the very subject matter of the action, in the sense that the issue cannot be resolved without determining it. It may be helpful to go to Bell Hadj just to see what else Lord Sumption said at volume 4 of the Authorities, tab number 22. And if we pick it up, please, in the law report at page 1154, Lord Sumption at paragraph 240, just above letter E, says that some such distinction, that's the Kirkpatrick distinction, is essential if the Act of State doctrine is not to degenerate into a mere immunity against international embarrassment. The principle is implicit in many of the English cases, but it can best be illustrated by the decision of the United States Supreme Court in Kirkpatrick. And then he explains what happened there. Environmental tectonics had succeeded in a competitive tender for a construction contract with the governments of Nigeria. The plaintiff, an unsuccessful bidder, alleged that the company had bribed Nigerian government officials and claimed damages under various US federal statutes. The receipt of bribes was illegal under Nigerian law, but the Supreme Court held that the Act of State doctrine did not apply because the legal implications of bribery in Nigerian law were not a necessary part of the plaintiff's case. He had only to prove that the bribes had been paid and that environmental tectonics had thereby committed an act unlawful under US law, that the facts would incidentally disclose offences by the bribed officials was irrelevant. Justice Scalia, delivering the judgment of the court, held that act of state issues only arise when a court must decide, that is, when the outcome of the case turns upon the effect of official action by a foreign sovereign. Can I invite the court's attention to Kirkpatrick, which is at volume 8 of the authorities, at tab number 40. And if and can we pick it up, please, at Law Report page 705. This is the Supreme Court Reporter. And in the left-hand column, halfway down the new paragraph, petitioners point out, however, that the facts necessary to establish respondents' claim, petitioners were seeking to have this struck out, will also establish that the contract was unlawful. Specifically, they note that in order to prevail, respondent must prove that petitioner Kirkpatrick made and Nigerian officials received payments that violate Nigerian law, which would, they assert, support a finding that the contract is invalid under Nigerian law. Assuming that to be true, it still does not suffice. And then there's a reference to some authority, and about 10 lines down. Act of state issues only arise, this is the passage that Lord Sumption referred to, act of state issues only arise when a court must decide, that is, when the outcome of the case turns upon the effect of official action by a foreign sovereign. When that question is not in the case, neither is the act of state doctrine. That is the situation here, regardless of what the court's factual findings may suggest as to the legality of the Nigerian contract. Its legality is simply not a question to be decided in the present suit, and there is thus no occasion to apply the rule of decision that the act of state doctrine requires. And then over the page, 706, the middle of the page, new paragraph, petitioners insist, however, that the policies underlying our act of state cases, international comity, respect for the sovereignty of foreign nations on their own territory, the avoidance of embarrassment to the executive branch in its conduct of foreign relations, are implicated in the present case because, as the district court found, a determination that Nigerian officials demanded and accepted a bribe would impugn or question the nobility of a foreign nation's motivations and would result in embarrassment to the sovereign or constitute interference in the conduct of foreign policy of the United States. And then there's some detail. There's a reference to what the court had said in the right-hand column in an earlier case. And then there's the rejection of this on page 707 in the left-hand column, subparagraph 2. The short of the matter is this: courts in the United States have the power and ordinarily the obligation to decide cases and controversies properly presented to them. The act of state doctrine does not establish an exception for cases and controversies that may embarrass foreign governments, but merely requires that in the process of deciding, the acts of foreign sovereigns taken within their own jurisdiction shall be deemed valid. That doctrine has no application to the present case because the validity of no foreign sovereign act is at issue. So it's not, it doesn't exclude the application of the Kirkpatrick exception, that it is implicit in the case being presented that the Nigerian officials, here the Ugandan officials, acted unlawfully. What matters is whether the English court or the US court is being asked to determine the validity of a foreign sovereign act, assuming I'm wrong on the commercial sovereign distinction. And we're not asking the English court to assess the validity of any act of the BOU. We're not seeking to have the sale set aside. We're only suing the defendants. We're not suing the BOU. It is true, and my friends have made this point forcefully in their skeleton arguments, it's true that it is implicit in our claim that the officials took bribes, and unlawfully so. But that is not, in my submission, a bar to the application of the Kirkpatrick exception as explained by the United States Supreme Court and as approved by the Supreme Court of the United Kingdom in both Garhach and in Madura.
Can I just try and understand how that applies to the causes of action?
Yes,
Pleaded. As I understand it, there are three of them: unlawful means conspiracy, dishonest assistance constructive trust, and knowing receipt constructive trust. If we take first those last two, they are ancillary causes of action which depend upon there being a breach of duty by the Bank of Uganda. So far as those are concerned, is it not a necessary part of the cause of action that the court would have to determine that unlawfulness by the Bank of Uganda?
well, it's certainly implicit in that claim that there was illegality by the officials of the Bank of Uganda, but we're not seeking to establish the invalidity of any act of the officials of the Bank of Uganda. It's implicit in our argument, as it was in the Kirkpatrick case itself. That's my answer.
Is it not explicit? Is it not explicit for those causes of action that there was a breach of duty which has been dishonestly assisted?
It's certainly part of our case that we have to establish unlawful action. I accept that, but I maintain the position that it's implicit rather than a challenge to the validity of a foreign sovereign act. That's the distinction
The difficulty with that argument is that Mr. Justice Scalia does say, doesn't he, that the acts of foreign sovereign states taken within their own jurisdiction shall be deemed valid. So that in the question my Lord puts you, you're going beyond simply saying, well, this is what happened. I understand in the context of the bribery claim, you'd say it's all part of the background, but in the context of the other causes of action, it's a bit difficult to see how you sustain them without saying, well, the Bank of Uganda was in on the corruption or in on the fraud or whatever it is.
Well, I entirely accept that in relation to the non-bribery claims, our position is weaker. And I have to persuade your lordships, if I can, that a challenge to the validity of a foreign sovereign act means more than simply impugning the legality of that act. That's how I put it. I can't do more than that.
I follow that. In relation to what is not the non-bribery claim, which is a dishonest, is a unlawful means conspiracy claim, that also requires, doesn't it, establishing that there was an agreement with the other party, that is to say Bank of Uganda, that it would use unlawful means to cause damage. And so you face the same difficulty, don't you, in relation to that claim? You're either right in the way you've put it by way of answer, or that's fatal to all three causes of action.
Yes, it depends on the extent to which your lordships are going to interpret the scope of the Kirkpatrick exception as being excluded in any case where it is a part of the claim to establish the unlawful nature of the acts of the state authority in question. But what I say to your lordships is that that was true in the Kirkpatrick case itself, that it was a necessary, it was an inevitable part of the plea that was being made in the Kirkpatrick case itself, that the Nigerian officials had acted unlawfully. That's what Justice Scalia identifies at page 705 in the left-hand column, and in page 706 in the left-hand column. And he says that isn't good enough. That's not sufficient to exclude the Kirkpatrick exception. And it's not sufficient to exclude the Kirkpatrick exception because the substance of the claim is to focus on the unlawful nature of the acts of the defendants, those who had bribed. And I say the same is true in relation to the conspiracy claim. That's how I put it. There's no invalidity.
I understand that, but I'm just grateful for your confirmation that really
And
applies
if we go
across
back-
the board to all the courses of action.
If we go back to the pleading, and we go back to paragraph 69, which is on page 128, it's tab 7. What we plead there is the offer by the first respondent to enter into, and the entry by DFCU Bank into an agreement and transaction with the BOU with the features and for the purposes identified in the earlier sub-paragraphs, which conduct amounted to, and then we set out. So we're focusing there on the wrongdoing by DFCU Bank. And so all we need, we say, is a finding as against DFCU Bank in relation to that part of the case, not least because we have pleaded a conspiracy to use unlawful means by all of the defendants, all of the respondents together. So if I can't persuade
You can't have a conspiracy unless both parties agree.
Yes, but you can have a conspiracy between the first respondent, second respondent and the third respondent. That's the alternative way in which we put the unlawful means conspiracy, that they have all conspired together to bribe unlawfully the Bank of Uganda officials. That's how we put it. I take your lordship's point in relation to a conspiracy that involves the Bank of Uganda officials themselves.
Which is certainly at least one way to put it.
Yes. Yes.
But you say it's not confined to that. There's
I say it's not
alternative
confined to
conspiracy
that.
between the respondents.
And there is the alternative, which was put to me earlier this afternoon, that the offence, that the unlawful act is the act of bribery itself. And the act of bribery itself is an act which focuses on what was done by the defendants.
Well, that isn't a cause of action that's currently pleaded.
It's not. No. And that was what was put to me by my lord.
You do have to impugn, to use this neutral word, you have to impugn the process by which BOU, as you pleaded it, resolved your clients. Because if BOU acted properly and in good faith throughout, you would have no complaint.
Your lordship's correct. Your lordship's correct. But it's not enough, I submit, based on Kirkpatrick, that it is implicit in the pleading in the case for the claimants that the Bank of Uganda and or its officials acted wrongfully. That is not sufficient to exclude the Kirkpatrick exception, because that's precisely what the United States Supreme Court, as approved by the United Kingdom Supreme Court, says. And in that case, the conduct of the Nigerian officials was being impugned, had to be. It was a necessary part of the case. It was implicit in the complaints that were being made. So there's a very fine distinction here as to the circumstances in which, in a case that is not being brought against the Bank of Uganda, but the allegations, most of them, complain of unlawful acts by the Bank of Uganda and its officials, in what circumstances that falls within the Kirkpatrick exception and in what circumstances it does not.
We're always dealing with cases where it's not brought against the state, because if it was brought against the state, we'd be within state immunity.
That is true. That is true.
So it's not, it can't be an answer to it that it's not a claim against the OU. But we do see in 69, it starts with A, with abuse of office on the part of BOU. And then BOU committed tort and misfeasance, BOU committed the crime of corruption, crime of bribery, crime of abuse of office, causing financial loss. So there's no doubt that you are pleading and therefore seeking to establish something which doesn't appear to be incidental. Seems to be at the forefront. Seems to be at the forefront of your case.
Well, a great deal of 69 falls into that category. 69M does not, in my submission.
So what are you saying about the rest? Are you saying it doesn't have to be determined, or?
Well, I'm recognising, I hope properly, that our case on Kirkpatrick is much weaker, your lordships may say unsustainable, in relation to the other parts of 69. But as I indicated earlier, the Supreme Court in the Ukraine case recognised that if any part of the pleading is sustainable pursuant to the Kirkpatrick exception, that should be allowed to go forward to trial, and quite properly so. So I'm seeking to respond to your lordship's understandable criticism of the breadth of the pleading. The pleading, of course, is broad, because I say it is all sustainable pursuant to the public policy exception to which I'm
That's a
coming.
different point. If you're right about that, then this particular argument doesn't matter.
No, no.
But I mean, just looking at 68 and 69 together, it's all rather sort of entangled, and you'd have to extract from it what it was that fell within the Kirkpatrick exception. And
Yes.
if you're right about it, then
Yes.
there is a plea in 68 of a conspiracy together. That's a conspiracy between the defendants
Yes.
and with the Bank of Uganda. But I mean, it's conspiracy between the defendants, amongst other things, to give the Bank of Uganda and its officers the 100 billion portfolio, which was the bribe.
Yes. No, I accept that.
So that's if that plea is, as it were, severable, then it falls within Kirkpatrick.
Yes. That's how I put it.
Yeah.
And your lordships will determine whether any part of this pleading is sustainable pursuant to the Kirkpatrick exception. I recognise that much of it is not, or at least it's very difficult to argue that it is. I make no concessions, but I say that some of it is, and that part which is sustainable pursuant to the Kirkpatrick exception, I say should be permitted to go forward.
Yeah.
That's the submission in relation to Kirkpatrick.
Just before you leave Kirkpatrick,
Yes,
the way the decision is explained by Lord Sumption in Belharsh is that it wasn't necessary to the cause of action in Kirkpatrick to establish that the conduct was a breach of Nigerian law because the RICO cause of action was complete in the US courts if it was contrary to US law. And that was so that Kirkpatrick was not a decision which accepted the submission that you've shown us, that it was necessary to decide for the cause of action whether the conduct was a breach of Nigerian law. And that's why the court can say, in a case such as Kirkpatrick, it is incidental. But we're rather different, aren't we? Because we're only dealing with Ugandan law, and for the causes of action, we are having to address, or the court would be having to address, as a necessary ingredient to the cause of action, whether there was a breach of Ugandan law.
I accept that in Kirkpatrick the claim was pursuant to US law, and therefore it wasn't necessary to make findings as to whether or not the Nigerian officials had acted unlawfully pursuant to Nigerian law. But equally, I say, for the reasons I've given, that it is not necessary in order for us to sustain our pleading, at least in part, that the court needs to make findings that the Bank of Uganda officials acted contrary to Ugandan law. That's how I put it. And
Well, does it amount to this, that you say that what you're focusing on here is whether or not what the DFCU Bank and its officials did was contrary to Ugandan law, which you say it was because they sought to bribe the Bank of Uganda.
Yes.
No answer to that to say, well, incidentally, the same tort or the same crime was being committed by the officials of the Bank of Uganda. And that's the point I think that Justice Scalia is making, that it's not, you can't answer the first part of my analysis by saying, well, it's going to be illegal under Nigerian law and therefore the Act of State doctrine applies. Because that's not illegal under Nigerian law so far as the relevant officials are concerned.
That is the submission, that Justice Scalia was focusing on the lack of any need to resolve the question of whether the officials had acted unlawfully. It wasn't that the case was brought under US law rather than under Nigerian law. It was that it wasn't necessary to make a determination, far less a determination of invalidity, in relation to the conduct of the officials. And we say the same is here, at least in relation to aspects of our pleading. I entirely accept the case is much more difficult to sustain in relation to other parts of the pleading. That's how I put the Kirkpatrick exception. Yes. Public policy law, the third basis for addressing an act of state. And this is dealt with in Maduro again, Authorities tab 70, Authorities volume 7, tab 34, is paragraph 136, subparagraph 2. The doctrine will not apply to foreign acts of state which are in breach of clearly established rules of international law or are contrary to English principles of public policy, as well as where there is a grave infringement of human rights. And our case is that public policy does preclude the FAS doctrine from applying in this case of bribery and corruption. The corruption, of course, defrauded not only CBL, it also defrauded the the state. We say there is a relevant public policy, which is the need to combat corrupt practices and not give them legal protection. My Lord the Chancellor mentioned earlier this afternoon the COSA judgment of this court. Can I make some observations about that at the outset? Your Lordships have COSA at Authorities Volume 6 at tab 33. And my Lord will no doubt have in mind what my Lord said in particular at paragraph 151 of the judgment, which is on electronic page 1893, where your Lordship said that Mr. Scott sought to argue that cases like Oppenheimer may not exhaust the exception, that's the public policy exception, but are an example of it. But to the extent that this was a suggestion, the exception is of potentially wider scope, that is misconceived. Both Oppenheimer and Kuwait demonstrate that something very flagrant must have occurred before the exception is engaged. The case of Oppenheimer, so-called law constituting so grave an infringement of human rights, as not to be a law at all. In the case of Kuwait, a gross violation of international law amounting to piracy. Lord Justice Ricks pointed out in UCOS the exception is a narrow one, as Lord Hope recognised in Kuwait, and in UCOS this court refused to extend it to expropriation without compensation. Nothing in the judgment of Lord Newberger in Belhaj cast doubt on the narrowness of the exception. And I, for my part, wouldn't quarrel with any of that. As a statement of general principle, we need to show something flagrant. We say on the facts as pleaded, this is a flagrant case of bribery and corruption. We respectfully point out that COSA did not itself concern corruption in the sense of bribery. My understanding, Your Lordship of course will correct me if I'm wrong, but the complaint in COSA was essentially of political bias in the judiciary and in the executive. The Court of Appeal judgment, Your Lordship's judgment at paragraph 19 refers to a corrupt Turkish judgment, and the substance of the complaint was not corruption in the sense of bribery, it was a complaint of political partiality. It is not, I would respectfully comment, surprising that the appellant's attack on the Turkish judgment for political bias failed when those complaints had already been considered and rejected by the Turkish Constitutional Court and indeed by the European Court of Human Rights. That was the context in which Your Lordship made the observations.
Twice.
And indeed, because of the nature of the issues in COSA, alleged political bias by the judiciary, none of the materials to which I am going to draw this court's attention in relation to corruption, in the sense of bribery and corruption and public policy, were addressed in the judgments of Mr. Justice Trower at first instance or in Your Lordship's court. And I understand they were not part of the argument. They simply weren't relevant to the issue that was there advanced. And so it is my submission that the question of the public policy exception, whether it applies in the context of FAS to bribery and corruption, is not an issue which has been determined by COSA. It is, I respectfully submit, a novel issue, and it's, I say, not an easy issue. And it may well be that the court will think that this is an issue which, by contrast with the commercial sovereign distinction, and by contrast with the Kirkpatrick exception, should be decided on the basis of the facts that are found, and not at the stage of a strikeout. And it's in relation to this aspect of the claim. I appreciate the pleading was rather, the skeleton arguments are wider, but it's in relation to this part of the claim that I do rely on the general principle stated by Lord Collins for the board in the Ultimo Holdings case. Can I remind the court of what was said by Lord Collins? Volume 3 of the Authorities, my lords, at tab 17. And the relevant, this was a case where the issue was the appropriate forum. Some of the parties were saying they could not obtain justice in the foreign jurisdiction. And Lord Collins stated the relevant principle at paragraph 83 through to 85. This is page 1825 of the law report, page 864 of the electronic report. Page 1825, paragraph 83 of tab 17. Lord Collins, speaking for the board, says this: what is the position if the viability of the claims depends on a substantial issue of law? Is the court bound to decide it at the stage of the application to set aside service out of the jurisdiction? The general rule is that it's not normally appropriate in a summary procedure, such as an application to strike out or for summary judgment, to decide a controversial question of law in a developing area, particularly because it's desirable the facts should be found, so that any further development of the law should be on the basis of actual and not hypothetical facts. There's a great deal of authority. And paragraph 85 in Seekonsar Far East Limited, Lord Gough said that if at the end of the day there remained a substantial question of fact or law or both arising on the facts disclosed by the affidavits which the plaintiff bona fide desired to try, the court should as a rule allow the service of the writ. The standard of proof in respect of the cause of action could broadly be stated to be whether on the affidavit evidence, or I would say the pleadings before the court, there was a serious question to be tried. And we say that there is at least a serious issue to be tried relating to public policy. We would respectfully submit that the following principles are established by the case law in relation to public policy. The first is that the public policy exception is flexible and it depends on contemporary standards. The authority for that proposition is Kuwaiti Airways, numbers 4 and 5, not the same judgment as I showed the court earlier. This one is in Authorities Volume 2, tab number 11, Electronic 364. And here the appellate committee applied the public policy exception so as to defeat Iraqi Airways' reliance on Iraqi law to establish the legality of its use of Kuwaiti Airways' fleet of airlines. And I draw attention to what Lord Nichols said for the appellate committee at page 1081, paragraph 28, where his lordship said the applicability of a provision of foreign law must be judged by contemporary standards. Lord Wilberforce, in a different context, noted that conceptions of public policy should move with the times. See Blathwaite and Corley. And Lord Hope, to similar effect, at paragraph 145, which is on law report page 1110, paragraph 145, his lordship also cited what Lord Wilberforce had said in Blathwaite. And to like effect, don't think your lordships need to turn it up, was Lord Sumption in Bell Hadge, Authorities, Volume 4, tab 22, at paragraph 250. That's the first principle in our submission. The second principle is that the relevant public policy considerations depend on domestic law, but generally accepted norms of international law are of assistance. But it's a domestic law test. And one sees this from Bell Hadge, which is in volume 4 of the Authorities, tab 22, at paragraph 153. So we pick it up at 153, which is on page 1119 of the law report, 1217 of the electronic bundle. 153, Lord Newburger, speaking for the court, says it's well established, the first rule, namely the effect of a foreign state's legislation within the territory of the state will not be questioned subject to an exception, that such legislation will not be recognised if it's inconsistent with what are currently regarded as fundamental principles of public policy. In 154, the circumstances in which this exception shall apply appear to me to depend ultimately on domestic law considerations, although generally accepted norms of international law are plainly capable of playing a decisive role. And at 155, his lordship referred to Lord Hope's speech in the Kuwaiti Airways case. The public policy exception is not limited to cases where there's a grave infringement of human rights, but is founded upon the public policy of this country, plainly a domestic standard. And at 168, paragraph 168, which is page 1122, letter F, picking it up at letter F, as explained above, because the doctrine is domestic in nature, and in agreement with Lord Manson's assumption, I do not consider it necessary for a claimant to establish that the treatment of which he complains crosses the international law hurdle before he can defeat a contention that the third rule applies. Similarly, Lord Sumption, paragraph 261, which is page 1164, at the end of paragraph 261, 1164 letter H, just above letter H, it follows there's an exception to it does not need to be based on a countervailing international law obligation in order to accord with principle. It's enough. The proposed exception reflects a sufficiently fundamental rule of English public policy. That's the second principle. Domestic law, it's a domestic principle, but international law assists. The third principle, as to what material assists in identifying public policy, Lord Sumption in Bell Hadge, Lordships still have that open, volume 4, tab 22, paragraph 266, which is on page 1166, just under letter D. His Lordship says, it's no answer to these points to say these treaty provisions are concerned with criminal law and jurisdiction, so they are, but the criminal law reflects the moral values of our society and may inform the content of its public policy. And I draw attention to that because I'm going to show you, Lordship, relevant provisions of the Bribery Act 2010. Also, Lord Hope in Kuwait, I've got my eye on the clock, my lords, Lord Hope in Kuwait at Authorities Volume 2, tab 11 on what assists in identifying public policy. His Lordship at page 1110, paragraph 145. I've read this passage already. It's at letter D. Conceptions of public policy should move with the times, and then this, and that widely accepted treaties and statutes may point in the direction in which such conceptions, as applied by the courts, ought to move. And the fourth principle, also of importance to public policy, is any threat to the rule of law. That's of particular significance. The same authority, Kuwait, Lord Hope, in the same paragraph, paragraph 145, if the court still has it open, authorities, volume 2, tab 11, page 1110, paragraph 145 at the end, just above letter F. It is now clear, if it was not before, that the judiciary cannot close their eyes to the need for a concerted international response to these threats to the rule of law in a democratic society. Their primary role must always be to uphold human rights and civil liberties, but the maintenance of the rule of law is also an important social interest. Lords, we're a long way from the mischief that occurred in Kuwait Airways, but I will submit, that we are here concerned with a potent bribery and corruption. We are concerned with a potent threat to the rule of law. And I'll make that point in a moment. And the fifth principle is the one I've already identified and accepted, certainly in your Lordship's court from COSA, that the public policy exception does require something very flagrant to have occurred. And your Lordship emphasised the narrowness of the exception. Plainly, the exception can't swallow the rule. So those are the principles. The issue of whether bribery and corruption is contrary to public policy in this country, I'm coming to. Can I just show your Lordship's one further authority before I come to develop my submission tomorrow on why bribery and corruption are contrary to public policy to the extent that the FAS doctrine does not apply. And that's the case of Attorney General of Hong Kong and Reed, which is in Authorities Volume 1 at tab 8. This was a case concerning a Crown servant, Volume 1, tab 8, page 298 of the electronic bundle. A Crown servant in Hong Kong who was in breach of his fiduciary duties to the Crown by accepting bribes for the performance or non-performance of his duties. And there's a statement by Lord Templeman, who always put matters in a pithy manner. And Lord Templeman at page 330 of the law report, at the bottom of the page, the last two lines, said this: bribery is an evil practice which threatens the foundations of any civilised society. And that's the starting point, maybe the finishing point for our submission on public policy. Would it be convenient, my Lord? I notice it's just coming up to 4 o'clock.
It's probably convenient.
You stop there.
Very well, so 10:30 tomorrow morning.
Thank you, Lords.
Thank you very much.
All rise.